Good afternoon, and thank you for joining us today. I would like to welcome you to the FortneyScott webinar entitled Employment Law, What Hasn't Changed. This webinar will be recorded. Today's presenters are FortneyScott attorneys Leslie Silverman, Elizabeth Bradley, and Sarah Mugman. I will now turn the program over to Liz to start the webinar.
Hello, everybody. Welcome and thank you for joining us. For those of you who are not familiar with us, FortneyScott, we are a woman-owned law firm located in Washington, D.C. We often represent clients in matters in front of various federal agencies, employment law matters, EEOC. We have Leslie here with us. So we can go ahead and advance the slides to get past the who we are slide, a little bit more information. And also the necessary legal notice. We are not here to give you legal advice today. If you do have any questions, please, following this presentation, please reach out to your FortneyScott attorney and we can talk to you in more detail. But moving on to today's agenda. It was supposed to be what's not changed, but of course, when we sent out that notice to today, things have changed. So we're going to lead off the discussion with the executive order that was issued titled Restoring Equality of Opportunity and Meritocracy, easy for me to say. And then we are going to move into some of the things that have not changed, programs and practices that we recommend you continue to do even though in our changing landscape. So I'm going to turn it over to Sarah. I'm going to lead off with the new executive order.
Of course. So while this was just issued last week on April 23rd, it might not necessarily be a shock of what it contains. So what this executive order addresses is first going to be the administration's policy that they are going to eliminate the use of disparate impact liability to the full extent possible. The president also revokes presidential approval of certain regulations that are under Title VI that would impose disparate impact liability on recipients of federal funds. It also directs the Attorney General to work with agencies, including the EEOC, on amending or repealing regulations related to disparate impact theory. And it also orders all agencies to deprioritize enforcement of statutes and regulations regarding disparate impact theory. And the reason this isn't necessarily too much of a shock is that the Attorney General, when she stepped in back in February, had actually issued a memorandum to the DOJ asking them to narrow the use of disparate impact theories. And also of note, back when Project 2025 was put together, one of the agenda items was also eliminating disparate impact theory. So while this executive order is on the newer side, it is not necessarily a huge shock to all of us. But Leslie, can you share what perhaps the impact of this executive order might have?
Sure. Well, welcome everybody. My name is Leslie Silverman, and Liz mentioned EEOC. I was a commissioner and vice chair at EEOC a long time ago, and before that, I was a labor counsel in the Senate. And I mention that because there is a law that still exists, Title VII, and it was amended in 1991 to provide disparate impact. So it's still in the law. And if you were to look at Project 2020. It would say, well, we're going to repeal that, but the president moved forward with this executive order. I also want to just give one comment. The things that are moving fast right now in Washington include pollination, and I am suffering from allergies. So I want to apologize for that. It's beautiful outside, but not great for those of us who have allergy-induced asthma. Anyhow, okay, so how does this executive order impact federal agencies and especially EEOC? Well, the law is still on the books, and anything the commission voted for, and I do mean the commission, such as regulations or guidance that talks about adverse or disparate impact, is still out there. So Andrea Lucas, who's the acting chair, cannot just dismiss it, but she can deprioritize and has been deprioritizing in accordance with the executive order what her agency can do in terms of investigations or enforcement actions based upon disparate impact. Now, I'm not sure that message has necessarily gotten to the EEO field. For those of you who are dealing with subpoena enforcement actions or requests for information, I think it's an interesting time, and we'll have to see. But you need to keep that in mind. Now, your takeaway message from this should not be that you need to stop analyzing outcomes of employment decisions or cease conducting adverse impact analysis, especially in situations like reductions in force and layoffs, but not only in those, because there's lots of reasons to do that. Rather, we start off with this because, one, it's the newest development, ironically, in a webinar supposed to be focused on what didn't change, but because it is going to impact how the federal government handles these issues. But it is not, because it's still in the law. It's still the law of the land, the federal law, and private litigants, private civil actions, class action attorneys are still going to use it. Statistics can still be used as part of a pattern of practice, as Liz is going to talk about briefly. And really what we're saying is be mindful of this, use it, and also consult with your counsel, because you really want to make sure that when you're doing these things that it is privileged whenever possible.
Yeah, I think it's also important to note as well, EEOC may not go after disparate impact if you have an employee or that are filing with their state agencies. The states are still going to be going after these theories of discrimination. So it's not gone, and I think the scope of the impact of this is likely going to be somewhat limited just to the federal agency enforcement mechanisms.
Right.
Leslie.
Although one of the requirements is that the attorney general is supposed to go out and try to fight conflict with states, and not just states, localities, particularly in the AI area, which I think is what was driving, right, a primary driver of this move. And we have seen cities put together rules and regulations about using AI tools in employment. So please be mindful of those. Okay.
The next piece we're going to talk about a little bit is just, and this is just a back to basics, so we're not going to spend a significant amount of time, but it's just sort of reorienting ourselves about what the theories of discrimination are. So we just heard disparate impact is what the administration is wanting to remove, and that is when an employee's policy or practice is facially neutral but negatively impacts employees belonging to a protected class. So that is what they're saying they're going to not be enforcing on. Still have disparate treatment, right? Employee intentionally treats an employee differently because of a protected class. We also have the pattern and practice, and the sort of pattern and practice discrimination is sort of that blended gray area between disparate treatment and disparate impact. And in that, kind of thinking about an employer intentionally engages in systemic disparate treatment of specific protected classes. So easy for me to say all of this today. So just keeping in mind, these are sort of the thresholds of how an employee could come to you and set forth a claim of discrimination.
I want to add 2 more points on that. You'll notice that if you if you're before the EEOC a lot, that they don't usually name the theory that they're going after. So you don't always know. Second, disparate impact does not have the damages of the other 2. Pattern and practice has both, but it's a laborious process. So, I mean, disparate treatment is probably the easiest way to prove discrimination these days and the least confusing, but they're all applicable. And I think pattern and practice, we're going to see just a lot more in that area.
Agreed. So now we're going to switch over to talking about conducting barrier analysis, why you should still be doing them. We were doing them prior to the change of administration, prior to the number of executive orders, and Leslie's going to talk us through what we should still be doing.
Okay, wonderful. All right, so I'm going to talk about 4 areas that are, well, at least 3 are related. And the first has to do with recruitment process. This seems very obvious, and most of you know this, but optimizing your website is really important, because in most cases, what is the first thing that somebody that might be interested in your business is going to do in working for you? They're going to look at your website. And it is always an opportunity to highlight your company's values and culture. And there are things that you can do to attract talent through just your website, testimonials, etc. Using images and messaging that reflect an inclusive and welcoming workplace. And if your organization regularly or even occasionally uses paper, brochures, flyers, or other paper recruitment materials, and really that is necessary in certain instances because that alone can reach a different audience, you should be taking a look at those as well. They're a little more difficult to reprint, but sometimes so are websites. Second, your job qualifications. I think you need to take a fresh look at them. Your job descriptions, are they clear and concise? Do they accurately reflect the required skills and responsibilities? Are the requirements current and are they necessary to perform the job? And do they include necessary qualifications? I mean, do you still need a specialized degree, licenses, or experience?
Actually, for this one, I would say if you are a federal contractor, this isn't a recommendation, it's a requirement under Section 503. You still are required to, for individuals with disabilities, you are required to assess those job qualifications and show that you have done that assessment. So not just a best practice recommendation, it's a regulatory requirement for some of you.
And related, your job postings, you should update those. As with job descriptions, you need to ensure that the posting accurately conveys what is required. But job postings are your outward face, and your company may have been fabulous in putting them together years ago, but how long has it been since you really took a fresh look at them? Do they work in today's world? Or are they like that old movie or show that you think fondly of, and then you show your child and you're just mortified that it did not age well? Because look, how we think about and look at things is different these days. So you need to consider your word choice. Is the language appropriate? Is it inclusive? Can it be gender neutral? I think that's easier these days. Is your language plain? And avoid exclusionary language and review for a legal language. I don't think everybody realizes, people hear about digital native being off-putting, but it is a red flag for the EEOC. And recent grad is actually not permitted under the regulations. So these are just easy things to avoid. Lastly, expand your employment sources. You cannot have a diverse workforce if you don't have a diverse candidate pool.
Absolutely.
So moving on. So the next thing I wanted to talk about briefly was barrier analysis in the selection process. I think you've all heard this before, but using structured interview formats with predetermined job-related questions is so important. It may feel a bit stiff, but study after study shows that using these standardized questions will enhance fairness, they'll minimize bias, and they'll lessen subjective assessments. And if your hiring decisions are challenged, it's a great defense. So there's lots of good reasons to do it. I mean, people can still be them in the interview process, but it's really helpful to start with that template. Second, go back and train all participants in the process. And that includes both the folks that are doing the interviewing and those that are involved in selection. They need to know what they can and cannot say, because you'd be surprised what they do say sometimes. Staying within the legal boundaries, which includes avoiding improper discriminatory questions, reminding them of the reason you used your standardized questions, and applying consistent criteria, and educate them on recognizing and reducing implicit bias. You don't have to even use the word bias. You can just talk to them about, do you notice this or that? There's ways to say things to people and just make them mindful of things that we do, like talking with our hands. Okay. These steps will reinforce accountability and compliance. Lastly, analyzing hiring versus hiring an applicant and availability. Liz,
Yeah,
take it from there on that one.
There's a lot of great information that you can find about whether there are barriers in your selection process by the data that you're collecting. one of the first things, just looking at and assuming you're collecting applicant self-ID information, looking at, is there a diversity in that applicant data? To Leslie's point earlier, you can't build a diverse workforce if you don't have diverse individuals applying. So look at the race, gender, disability, veteran status, self-ID of your workforce. Look to see if you're not, of your applicant pool, excuse me. If you're not seeing a diverse, you need to go back to your talent team and say, where are we recruiting from? Why are we not bringing in more diverse people? I think that's one of the foundational pieces you need to be looking at is your outreach and recruitment effective? The other thing you need to be looking at is from who hired to who you were selected. And this is the basic of looking at your applicant pool to your hires to see, is there any selection disparities based on any of the protected categories? What is and looking at that and what's causing that disparity? Is there a selection process? Is there a hiring manager? And getting to the root cause of why, for example, women or whatever the protected class are not being selected at the appropriate rate compared to who has applied. If you're not collecting applicant self-ID data, you can also you can compare your availability data using census data or other available data about what's available out there in the talent force to the percentage of what your hires are to see whether or not there is a disparity between your hires and availability data. That's not quite as telling, but it is something that you could be doing. So I think it's really important to step back and think about the data that you have and how you can use it to identify where and how you're not having diversity in your workforce.
Okay. Are we ready?
We're ready. Moving on. So I got my
Okay.
phone.
So that barrier analysis and training and development. Now, equitable access to development opportunities. I think, well, recently workforce development efforts such as training and mentorship have been targeted by the DEI movement. We're here to remind you that they remain important components of your compliance efforts. Offering your employees development opportunities such as training, mentorship, as well as ensuring that they can grow by taking on challenging, they sometimes call it like stretch assignments, is really critical. But to be compliant, where feasible, you need to be offering your development opportunities to all employees. And where it's not feasible to offer it to everybody, such as a leadership program, not everybody's going to be a leader, you need to use objective, documented criteria for your selection of who's going to receive these development opportunities. Of course, you have to watch out in all this for patterns of exclusion, particularly based on race or gender or disability, and now more than ever. Okay, secondly, you want to be tracking your participation and your outcomes. You want to monitor who's receiving these things, and that's what I was talking about earlier. And you want to assess whether certain groups are underrepresented in your development pipelines. And you can use data to identify and address potential advancement barriers. I mean, sometimes people don't avail themselves of training, and the question becomes why. If it's women and your training is, I don't know, at the end of the day or remote, they just may not be able to get there because of their family responsibilities or events. I mean, there's lots of reasons, but figuring that out is the only way you can fix it. Lastly, well, I don't know if it's lastly, but you want to evaluate your training impact. Is it really useful? Training to train is just, a waste of everybody's time. So you really need to go beyond checking the box of attendance and measure the effectiveness and application of your training. And solicit feedback from your participants and supervisors. I am going to talk about surveys and feedback because I think it's incredibly important. But you notice that employees provide feedback in their own way, and even standing at the back of the room, if it's a live training and talking to people, if you're in HR but obviously forms. And if the training is going on and they're going to do it to future audiences, you can fix it in real time. So again, I think these things are critical.
One thing to think about there is when you're training, if it's online training, You probably have a reporting capability to see when do people drop. That is a real, if you see a bunch of your employees are taking the training, but they're dropping it 20 minutes an hour training and they're dropping out, they're not hearing it, they're not participating in it, and they're not finding value in it. Onesies and twosies dropping, they may have call, but if you're seeing a trend of employees not completing the training, something you need to be thinking about. And that's another place where data can give you some insight into whether employees find the training valuable.
Good point. And of course, if it's mandatory harassment training, they're like this with the button. But
Well, that's true. Yeah,
that's why
different.
it's important to have engaging training whenever you can. And it may not always be easy to find, but it is out there. Bias in evaluations and promotions. Again, performance evaluations are a big deal, Liz.
Absolutely. I mean, I think you need to be running some analytics on that and looking at trends about who is getting the high performing or not performing, and making sure there isn't any disparity based on protected category, and sort of some of that's some, unconscious bias and other concepts that come into the evaluation process, and being very mindful that you're checking for that. Because I think, what I'm going to be talking about in the next section, but to the extent you pay based on performance and evaluations are part of your pay structure, you need to make sure that there's not a bias based into your evaluation process.
I think all we're striving for is to know that, these opportunities are open to and distributed to employees fairly and equitably, because if they're driven by, networks of who and who you have in common with, you're just going to see it's not going to go well in the workforce, and people aren't going to stay, they're not going to participate, they're not going to give their all. So if they feel like their work environment and the opportunities are metered in a fair way, it's really going to go a long way for you. Okay, and then my last issue that I want to talk about in this section is one that's near and dear to my heart, employee surveys. Now, I don't just subscribe to the don't ask, don't tell approach in the workplace, because over time I found that it's more often what the employer did not know but could have that ends up harming them the most. So when it comes to workplaces, I personally don't believe ignorance is not bliss. I also believe there's oversharing, but you don't need to overshare, but there is it. Employee feedback is key. Employees will help you identify obstacles and perceived workplace obstacles that really aren't, but they think are. And if you don't know about them, you can't remove them. Now, I realize that as I say this, we are all suffering from survey exhaustion. You can't go to a doctor or talk to a customer service rep without being asked to complete one of those surveys. But please don't give up on using them in your workplace. I'm a big proponent of them, obviously. I think pulse surveys, culture surveys, exit surveys, but you need to a carefully worded, embedded, and thoughtful mix of relevant questions. It has to apply to your workplace. So by mix, I mean it could be ratings, most important to least important, and not too many of those, because those can get tedious. Multiple choice, because it gives, pick as many as they want. But I especially, and some employers shy away from this, am a fan of the open-ended questions. And those are what I often look at first. Both I do some monitoring sometimes for people who have entered into settlements with the EEOC, and I will look at the statistics, but I really want to see what the people say. That does not mean I believe everything. Some people have beefs, we all know that, but I think you can find out a lot from those open-ended questions, especially ones without too much word limitation, because when you're trying, some of us are not good at summarizing, as you know. Anyway, that I'm talking about myself. And for employees to be truly honest, they need to trust in the process. They need to believe that they won't be retaliated against for providing feedback. So in most instances, I recommended that the employees can respond anonymously, because privacy considerations really have to be paramount. When an employee in a small group is being asked to provide feedback about their manager, those employees need to know that their survey responses will not end up in front of their manager, because the manager's going to be able to tell if there's 4 or 5 of them.
Exactly.
And I advise clients to take the time to educate employees about their privacy considerations that they put into the survey in advance and get buy-in. Another option I'm also a fan of is having third parties conduct surveys, do it, you can do an interview survey process. It's incredible. Some people just do a better job of telling how they feel in those situations. Okay, so I have some other talking points here that I want to talk about, just briefly. Workplace surveys provide employers with insight on how employees perceive fairness in recruitment, promotion, training, and workplace culture. And they do, these anonymous formats can surface barriers that aren't visible. So I think it's important to consider that. They also diagnose hidden disparities. Because without sufficient privacy protections in place, you may not see those. And so looking at the results to identify gaps between policies and practices is very important. We've all seen great written policies, but if they don't meet the practices and you don't know that because you're sitting in headquarters, it's a problem. It's the first thing that comes up really in a lot of times before the EOC. And finally, you have to drive the action with the data. Use your results to inform your compliance efforts. Another point here is that employees also need to believe that their voice matters, that they're not simply going through the motions. That's a waste of our time as employees, and nothing will come of it. So sharing your survey results with your workforce and action plans will go a long way if you're able to do that. Communicating those steps will make a difference. And lastly, monitor your progress. Track whether your initiatives are reducing barriers and whether they're working over time. Okay, moving on.
All right, pay equity analyses. So this is again the land of what hasn't changed. So we can move to the next slide. Starting with the Equal Pay Act. It's still there. Nothing has changed there. And as a reminder, it requires men and women to be given equal pay for equal work. You have to have substantially equal work, and there's a lot of factors. We could do a whole day on this, so that's not the point of today's process, but looking at the work, their location, various factors to get the tight grouping under the Equal Pay Act that would qualify as substantially equal. What's really important is under the Equal Pay Act, there is no requirement that the plaintiff show a discriminatory intent. It's almost a strict liability type standard, and it is on the employer to bear the burden to justify any pay differences. So you really need to be looking at your compensation data to know, are there any situations where men are being paid more than women for equal pay or equal work? And you need to be aware of that and to be and adjusting for it appropriately. So back to Leslie's point is the sticking your head in the sand, don't ask your data what it's going to tell you, don't look at it. That's not where any of us need to be, even under the new administration. So I think that's very important. In addition, we also still have all of the federal anti-discrimination laws in the next slide. Title VII, ADEA, ADA, all of those still apply, still require they prohibit compensation discrimination. And this is a little easier to establish. They're broader groupings. It's a standard of similarly situated, so it's less stringent than the comparator groups under the Equal Pay Act. And you're going to be looking at skills, efforts, responsibility in building those groups. Here, the burden is on the employee to establish that the employer's reason for the differential is pretext. So the burden is slightly more on the employee when establishing a claim. But the bottom line is we still have both of these federal laws that require non-discrimination in compensation, and it places an obligation on employers to be ensuring that you do have equitable pay practices in place.
And let me add here that there really isn't a statute of limitations when it comes to pay. Every time it shows up in an employee's paycheck, it renews the clock. So these are things that aren't going to go away. So it could have been something you did a long time ago, but as Lily Ledbetter and that change made, that was already in one of the statutes, but it was made Title VII. It makes a big difference. So
exactly. So these are continuing issues, and I know everybody's really focused on DE&I, etc. pay discrimination is not a DE&I concept. It is a non-discrimination concept that's going to continue.
And I think, in case you didn't say this, and I'm sorry if I repeat myself, if you are going to conduct one of these efforts, fix it.
Well, we're going to get there.
Okay.
We're absolutely going to get there. Absolutely
Okay,
gonna get
all
there.
right, sorry to jump the gun.
The other legal landscape is on the next slide. And what hasn't changed is the states are getting active. And that's going to continue to happen. So we currently have 14 states with affirmative action obligations. Many of them within those state affirmative action obligations have a requirement to be looking at compensation. They have various obligations. I'm not going to spend any time running through each of the state AAP laws. I'd bore you all with that. But you need to be mindful that you may have a state obligation under your AA, under the state affirmative action. There's also state pay transparency laws and state pay reporting laws. If you have an obligation under one of these states to report, and there's more coming, we hear of other states that are going to bringing it out, you need to be testing your data that you are reporting to the state to find out, is it going to disclose any sort of pay disparity problematic issues in your data? Test it. Is there a problem? Do remediation. If there is a pay disparity that is not based on business reason, legitimate factors, correct that before you're submitting your pay reports to these agencies. You have an obligation to be thinking about that and doing that.
Liz, are any states that you've noticed a little bit more bold than others? I mean, is there any that
I think the obvious one is California.
Yeah,
Let's just start there. But I think there's a nuance to be thinking about on each one of these states about how their data is reported and the different gotchas in all of them. But and again, we could do a whole state law session if you'd like to. So moving on to the next thing is when we start thinking about these and starting to think about, are you going to do a pay analyses and how to do it, is how are you going to group your employees? And there's a lot of different standards out there in each of the states. So again, we talked about, federal Title VII and the other federal anti-discrimination is similarly situated. But then each of the states have their own tweaks on that. And there's a lot of similar words being used, but they're not similar. Yeah. They're not, sorry, didn't mean to do that. They're not always interpreted the same way. So California, for example, is substantially similar. Washington State is similarly employed. Work of comparable character is what is the language in Oregon. So we're looking at these, and you need to be very mindful looking at where you have your workforce, where it is. And we really do expect under this administration that the states are going to become more active. And so we were previously kind of thinking you can do a Title VII standard analysis and be pretty comfortable. Actually thinking you need to be looking at your workforce, and while yes, you need to be doing the broader Title VII analysis, depending on the size of your workforce in the different states, you should also be starting to think about, do you need to be also doing subgroups based on the states in which you're in, especially if you're going to be having state-based reporting obligations. So being mindful of how you group your employees, I think is going to be very important in the next few years. Another real reason, moving to the next slide, another thing to be thinking about, and this is, the states are developing safe harbors in their laws. And this is a really important thing for employers to be thinking about. If you have a safe harbor, some of the deep harbors are more of a complete affirmative action. Those are for complete protection, complete defense. Those are rare. The more shallow safe harbors. Under the shallower safe harbors, for example, I think Oregon is an example of this. If you can show that you've done a pay equity analysis within the past 3 years, that it conforms with their requirements. So that gets back to how are you grouping your employees? You could potentially avoid any compensatory or punitive damages if it is found to have a pay disparity that is not explained. That also goes to the issue, if you want to take advantage of one of these safe harbors, what are you going to be turning over in order to take advantage of that safe harbor? Again, nationwide pay equity analysis Or are you going to be carving out, especially in Oregon, for example, just analyzing the Oregon data so that if you need to establish that safe harbor, you're only having to disclose your Oregon data in order to establish that safe harbor? My advice would be likely only doing your Oregon data. So be thinking about these things, because as right,
The rule is never
Right.
give any government more than they need.
correct. But so these are a lot of reasons why it's much, I think, more focused than the prior concept of should we do a proactive pay equity under Title VII. And I think focusing on your compensation and looking at what states you're in, what laws are coming out in those states, and how can you proactively be taking advantage of these safe harbors, I think is incredibly important for employers to be thinking about moving forward. Now, on the next slide, and again, this is one slide covers topics that actually has done in a two-part webinar before. So we're going to get through this high level on here, but I think these are some really important concepts that we need to touch on today. First of all, if you're going to be doing a pay equity analysis, we highly recommend that you do it under privilege. You need to protect this work product. One of the main reasons is you want the freedom to really delve in deeply. And if there's an issue, you want to really know the truth of the issue, the scope of that issue. Your lawyers know the truth of that, so that you can do corrective action remediations as needed, rather than a surface level review that only discloses what you would be comfortable having seen by the public. So get that privilege in there. Privilege also lets you work the groupings and work the factors and find some of the problems and analyze it appropriately. The privilege isn't trying to hide this, it's allowing you the freedom to do the work and do the real work in a deeper manner. I think that's important. The groupings, I think I've hit on that a lot. Think about this, and I think doing your analysis with multiple different types of groupings based on the various laws that are going to be applicable to you is going to be a new foundation to how you run these. Nationwide versus state specific, I think, is going to be how you're going to have to start doing that. Also within these groupings is how it is the foundation of your pay philosophy. Who are the employees who should be properly compared, and thinking about that big enough to do analyses on, but not so large that you're combining unlike employees. So that takes a lot of work. And I think that needs to be tested out and analyzed in a few different ways. Factors, I think, this goes back to what Leslie mentioned also. What does your policy say? What does your practices actually say? Run the analysis with what the factors your pay policy says you're paying for, time and job. There's other certifications if you have that in the data, but prior experience, using the factors you have data driven for. And if your policies are saying you're paying for time and job, then you're running the analysis and you're realizing that time and job is actually not predictive of pay. That often happens, right? Because your policy is written, you think this is what you're paying on, but actually boots on the ground, that's not what's driving pay. And it's actually your performance measures, your merit increase. So often one of the outtakes of a pay review is you modify your policies. You update them so that your employees know what they're actually being paid on. And I can tell you have a thought.
Yeah, I wrote it down, outliers, because you're not only saying what drives employee compensation, but what is causing your outliers. I mean, you spend a lot of time like that. The person moved and they were abroad, whatever, they have some bump up in pay from something, and they're just sitting there, and being able to identify and explain those differences is important. Sometimes you're not going to change them because you can't, but at least you can explain them. And I think at least that's how I have handled in the past.
Absolutely. And I think going to that point, one of the things is as you're doing the investigation, if you find outliers and you're finding a theme, these are all high outliers because whatever the fact, you find a new factor that you're paying on, you may rerun the analyses and putting in these new factors. I'm going to remove time and job and I'm going to add in, because maybe we thought we weren't paying on performance score, but we were paying on time and job. I may remove the time and job and I may add in the performance factor and rerun the analysis and see what is that giving me and how is that showing. Running the analyses, and you'll get an expert in to do that. Your lawyer won't be doing the regressions, the Fisher's exact, the t-test. One point here I just want to caution on: don't create groups that are large enough so that you can do a regression just for the purposes of creating a large enough regression group. Some you're going to compare dislike people and create not meaningful analyses. Sometimes you just have to go down to a percentage difference if that is how small your groups are, and be comfortable with that and do that. To the point where Leslie was going to, you're going to investigate. Any grouping that has a flag, investigate. You're going to get your cohort reports. You're going to show your high outliers, your low outliers, but everybody in the middle. Don't just focus on the outliers. The outliers are telling you kind of where to start, but you need to be doing a full detailed investigation to understand why those people are outliers. You will also remediate anybody that is not based on a legitimate business reason, that for their pay difference. But if you are seeing in there, for example, I think I'm hoping most of you are not in this world anymore, but if there is the overall group has a disparity against women, but you are seeing in your investigation that there are also men that are paid too low in your investigation, you are going to be remediating regardless of race or gender. You're not only going to be remediating the minority or women class. And that's very, very important that you are looking at. Yeah.
And of course, people probably know this, but you can never lower someone's salary to remediate. It's just not, I mean, right?
No,
yeah.
Never.
You looked at me, I was like, wait, that's a pretty bedrockal. Okay, I got nervous. I was speaking out of tune, but
But what you can do is red circle.
Yeah.
So do you have somebody who is above the pay group to their peers? You're not going to remove any pay from that person, but it's absolutely appropriate to red circle, pause them until it's time for them to be adjusted up. And so now I'm going to move on to pass it back over to Sarah to talk to us about reasonable accommodations.
All right. So one other thing you guys have all been doing have been providing accommodations. Or perhaps some unreasonable from time to time. But nonetheless, they all will fall under either Title VII, for religious-based accommodations. You've got the Americans with Disabilities Act, and also pregnancy-related accommodations under the Pregnant Workers Fairness Act. And so one of the things that an employer will have to consider when receiving a request is whether providing that accommodation would be an undue hardship for that employer that would cause them to deny the request. And of course, this is a particularly important step for employers to consider, given that this would be the basis for potential claims from employees. So I know, Leslie, we were talking earlier today just about this, and this is really kind of how just over the years, they're all kind of come into very various definitions of what undue hardship is.
Yeah, and for people in your workforce like me, if they're not paying attention to the law, they may not realize that back in the day, the ADA was the hardest undue hardship standard. It was very difficult to meet, but over time with changes, that's no longer the case. The newest law, the Pregnancy Worker Fairness Act, is it's going to take a lot for you to meet that. And religion is also a very difficult standard. And I think one thing, we have different words up here: significant difficulty, significant expenses, how it impacts the business, which is important. But the concept you should remember and we should pass on is undue hardship, incredibly hard to meet. Try to accommodate. The process, interactive process. Don't let the employee hang, and never let them hang with pregnancy. But go ahead.
And I think one of the things to touch on here is with respect to religion. Again, this one also over the last couple of years, as you're aware, has changed and become a more challenging piece to establish. And so just by way of example, I think in the last couple of years, a case that came out of the Fifth Circuit, for instance, where an accommodation requested under previous standards likely would have passed muster, now under the updated standard no longer does. And in that instance, it was an employee who is seeking an exemption from a grooming policy that required beards to be, a quarter of an inch or less, short hair. He worked in a prison. And so he was denied this request based off of safety and security concerns, saying you could hide contraband and a longer beard. And so he challenged this decision, and the court, the Fifth Circuit, sided in the employee's favor and did not believe that the employer of this prison here had met its standard of establishing an undue hardship, because the effect on the business was insignificant. It did not make that substantial cost. A couple more minutes of a security check on this employee as he steps into his shift is not going to create a significant burden on the employer. So that's just an example to show where in the past it might have passed muster, no longer does.
Yes, because before the DeJoy decision, which was 2 years ago, it was the de minimis standard. So the good news for you, if you had ever written that down, maybe, Word used to always tell me it was spelled wrong. If you see that in your position statements, take it out. You're just wrong. If your lawyer's advising you on that, rethink that, because it doesn't apply.
And the other reason, again, while we're focused on things that haven't been changing, there certainly has been an increased focus within this new administration on protecting religious freedoms. Upon Acting Chair Lucas stepping into her, at the beginning of this administration, she had made statements talking about her priorities being protecting workers from religious-based bias or harassment. She has recently chosen her chief of staff, who was a prior president of the Christian Employers Alliance. And they've actually an organization who had taken legal action against the EEOC based off of violations of Title VII on religious-based purposes. The president has issued a couple of executive orders focused on, protecting folks from anti-Semitism and anti-Christian bias. And also even just last week, as you can see, the group of folks we have here on this slide gathered as the task force to eradicate anti-Christian bias. So we can see that with this administration, there is certainly a prioritization of protecting folks' religious freedoms. And for that reason, we anticipate seeing an uptick in religious accommodation requests. And so we need to make sure that the management and HR professionals within your organization are not just familiar with these new standards, but being prepared in case they receive more of these requests.
Yeah, I mean, if you do one thing to take away from this part, is you really need to educate your managers to not only to understand that to recognize a request for an accommodation based on religion, and to phone a friend, to contact HR, to contact legal, whoever is handling it, because more often than not, they miss this. They just don't know. So if you're educating them to understand, all right, I'm not sure what to do with it, but I know that that's a thing, that'll go a long way.
I think another point here to make is this is likely, or it is not new, it's just becoming more prevalent. Over the pandemic, there was certainly an increase in religious accommodation requests due to exemptions from vaccine mandates. But we expect that it will continue, that you are, as employers, will see a variety of different types of religions. They also must be respected the same as, we see these executive orders about anti-Semitism or Christianity, but when you're considering these religious accommodation requests, the type of religion, it's not necessarily going to change the analysis here.
Right.
No.
If you have not heard of the religion, that doesn't mean that it's not a valid request that needs to be honored based on their religious beliefs.
Yeah, I mean, I worked on the first religious discrimination guidance from the EEOC, and they take those, everything in it, and it's very well done from the court decisions. And one of the things they say is religious beliefs are idiosyncratic. And so the person doesn't have to be tied to an actual physical church. You know, one of the cases that we were talking about the newness of the law, but back then it was the Church of Body Mortification, and that was a Costco case, and it involved an employee that did not want to cover up their tattoo. So just realize that, you know, you're going to see some zany, wacky things and some regular, you know, easy things and everything in between. But as we enhance religion, there's going to be a difference. I also think you're going to see changes from this administration and Congress maybe on religious employers. But unless you're a religious employer or working for one, don't worry about that. That will just be a separate,
Right.
we'll do a separate webinar if that's necessary.
Yeah, so the unique religion thing, it's not a new concept. We think it's just becoming more prevalent. And
Yeah.
I think the justification of religious based for not being vaccinated under COVID is sort of launched the increased prevalence of that.
Because people are aware of their rights now. Yeah.
Yep.
Yeah. Well, moving on to the next slide, actually, it's kind of a continuation of rights that folks are, it's well established. So at this,
Also continuing out of COVID.
also continuing out of COVID, we have certainly seen waves of employers
Keeps giving.
asking their employees to return to work. Even just at the beginning of this year, or upon the new administration, you had President Trump calling federal employees back into workplaces. Global or national banks have started in large news stories that you all have probably seen. Commerce companies calling their employees back to work even just within the last couple of months. So because of this, we anticipate that either folks who had accommodations before to work remotely, or those who worked from home during the pandemic and are being called back, you might see an uptick in new requests. But because this has been established that the employer can in fact provide this accommodation at what the employee is going to argue is a low cost to the employer, we think it will be particularly challenging moving forward for employers to establish that there's an undue hardship to continue providing that.
I mean, this is one of the things when we were confronted with the COVID, the EEOC issued some technical assistance guidance in pretty quick order, taking from the commission policy. But really what they were trying to say is, yes, you should be granting these and it won't necessarily be held against you later. But the fact is, when you've been home for several years and your work performance is fine and all is good, it's pretty hard to argue when they request a disability accommodation that it's not feasible. Now, there are plenty of reasons why you might want your employee in the workplace, but you have to balance that with the realities that you have a record against you. So obviously a receptionist, someone that has to be there on the factory floor, that's an easy one, but most are not easy, as our clients are seeing.
Well, I think that actually brings it to another issue that employers often have. It's related to documentation. You have granted somebody an accommodation. Is it going to be limited in time? Should you be rechecking that documentation to make sure that there is still a need for it? Are you maintaining, that documentation confidentially? Are you contacting the right folks at the right time? So of course, documentation of the need for an accommodation is also going to be important for employers to follow.
And there's a fine balance there. I mean, what the EEOC has said in the past is you can have a form, but the fact that the employee doesn't fill out the form, if they give you the same information and documentation, you can't hold them form over function there. Also, with disabilities, if it's a permanent disability, you can revisit to see if the accommodation is working, but you can't make the employee keep renewing like the request, because that is going to look like harassment. Mm-hmm. So apply common sense to this. One other thing I want to add to this slide, you cannot call somebody's priest or rabbi and ask if their accommodation is legit, but you can still contact their healthcare provider where necessary. That's allowed, it's permissible. And frankly, if you're going to reject something, you better do that first if that is a key component.
Mm-hmm. And as the last accommodation we're going to address today are going to be pregnancy-related accommodations. And as Leslie has pointed out, these are pretty much always going to be granted. It's very limited circumstances you should be denying these, mostly because one, as we discussed kind of with the under ADA, these ones in particular are going to generally be temporary, because pregnancy only lasts for a certain amount of time, and any effect on the employee's ability to perform kind of the things that they do on a day-to-day basis, those essential functions, things that are important, the need to suspend their obligations there are going to also be temporary. They're short in time. So to deny accommodations here or to rely on the undue hardship for pregnancy related accommodations is going to be particularly challenging. And especially when compared to the other two. And I think one other piece to note is we talked about documentation. Again, I think requiring documentation to establish the need for an accommodation for pregnancy related accommodations is going to be limited. The employers have more restrictions than under the ADA.
There's several areas where you can't request anything. Yeah.
Things like pumping or nursing at work,
right?
Or, things
bringing water at your desk,
water, whatever.
Really, if someone needs that accommodation, I mean, give it to them and give it to them quickly, because it's snap to it. Those first 3 months of nausea, they'll end, and if you haven't done anything, you're in trouble.
I also think it's important, and you can never force somebody to leave. So this is not unique under the Pregnancy Worker Act, but going up to recommending that a pregnant worker take a leave of absence is, I hear of it happening. And so I'm just reminding everybody that you cannot make a force a pregnant employee to go out of the workforce and take a leave of absence.
Even the reminder. The intent is supposed to be helpful.
But I mean, this goes back to case law in the 70s about working in a battery factory. You cannot decide for that employee what they can and can't do.
Correct. And you think you're doing it, you think you're being kind and approaching it that way, but that's not appropriate.
Now, a couple of things to keep in mind. We've talked about pregnancy like that's the only thing this law applies to, but it's pregnancy and related conditions. And one of the issues that's come up is some of the related conditions and how long this lasts go well beyond pregnancy. It's both getting pregnant, which so it could be 9 months before, and it could be 9 months after you give birth. But it could be, how do you know if you're trying to get pregnant, it's more than 9 months before. Right. So bear that in mind. I think that we're going to see, and it could be more than 9 months after, but I think we're going to see certainly the Pregnancy Worker Fairness Act regulations are being challenged, and I think you're going to see those changed at the EEOC, tightened, certain conditions they'll probably take out. But I do believe that Andrea Lucas, the acting chair of the EEOC, is very supportive of accommodations for, under the PWFA generally. So you will see the commission enforce that law.
Right. All right, so we're going to now turn to our final thoughts, and I'll lead this off, and I'll just say that I know we have the first quarter was a lot of reading executive orders, figuring out what the future is going to be, a lot of focus in the workplace on DE&I, but I think we all need to realize we can't ignore the everyday functioning of the workplace, the other non-discrimination laws, and kind of getting back to the business of ensuring there's not discrimination in your workforce.
Yes, and I think we're all, as Liz said, watching the news, but some of the basics, like I talked about surveys, do not forget how important workplace investigations are. They're, again, sources for you to learn, even if it's anonymous basis, what is going on in your workforce, because you can't fix what you don't know is broken.
And I think it's just kind of the recurring theme too, is just to kind of work with your employees, work with your workforce to try to make sure, not just through surveys, but again, things like accommodations, making sure everyone's paid favorably or paid equitably. It's really just kind of keeping the pulse on what's going on with your employees and making sure that you are, coordinating with them to reach the proper resolution or decision.
All right. Well, thank you all for joining us. Oh, one last thing is don't forget the FortneyScott resource page. There's a link will be in the documents. All of the executive orders, a lot of the government guidance and other materials are there for your easy access.
All right. Well, thank you for joining us. Sarah?
Thank you. We would like to thank you for joining us today. If you have any further questions, please email us at info@fortneyscott.com. A recording of this webinar and a copy of the PowerPoint will be available to all those who attended. This will be sent as soon as the webinar recording is available. Stay tuned for our next podcast and webinar.